And we're going to first introduce both candidates here. We have Capital Defense Attorney Dennis Moore. Thank you for joining us. I know that you had a bit of connectivity issues, but we're glad that you could join us. And we also have Criminal Court Judge Laurie White. So first, we'll start off with introductions where there'll be a period of 1 minute that both you can introduce yourselves and with your opening statements. And we'll first start with Judge White. Judge White.
Thank you. Thank you, everybody. Audio okay? You can hear me? Thank you. I'm Laurie White, and I've been a judge in Criminal District Court Section A for 13 years. I am an incumbent that should be reelected because I have always been progressive, efficient, compassionate, and an independent judge. I formed Reentry Court with Judge Hunter in 2010 and recently received a $1.6 million grant for the next 3 years to provide medically assisted treatment for heroin users in our community. I advocate for treatment and rehabilitation, not just incarceration. I came to the bench prepared, having been a trial lawyer for 20 years before I was elected to the bench, and I was first chair in more than 100 jury trials and over 75 judge trials. I have prosecution and criminal defense experience representing indigent clients and ones that paid. I was an appellate attorney where I briefed and argued more than 70 cited case decisions on direct appeal, post-conviction relief, and writs to the higher courts. In private practice, I successfully obtained the reversal of many convictions based on prosecutors withholding Brady or exculpatory material that was not turned over to the defense. I represented the city's community leader, Norris Henderson, and secured his release. I handled his matter for many years without pay and because I saw a wrong that needed to be right.
Thank you, Judge White. Mr. Moore, your introductions, 1 minute.
Okay. My name is Dennis Moore, and I am seeking the office of judge in Criminal District Court Section 8. I would like to bring to the bench the unique perspective of what needs to be done to make Criminal District Court Section A even better. I bring to you 23 years of experience as a criminal defense attorney. I actually started my career before going to law school. I was a person that worked as a computer science major from Grambling State University, worked for Siemens Energy, where I was a software engineer. You asked, why does that bring me to here? I believe that technology and streamlining the court system is what is needed today. I actually have practiced as a criminal defense attorney for 23 years. Part of that, I was actually a public defender where I actually handled hundreds of cases in the criminal justice in all sections of Orleans Parish Criminal District Court. I've also, for the past 10 years, worked as a staff attorney for the Capital Defense Project, where I actually handle first-degree murder cases and deal with indigent people. What I bring to this is a unique perspective, is that we need to change how things have actually been run, not only the past 10 or 13 years, but probably the last 20 years. It's time for us to streamline the criminal justice system. It's time for us to stop trying to over-incarcerate ourselves out of the problem that we have in this city. Me as a judge, I believe I bring a unique perspective because I can bring all of the different issues to make Section A and also the entire criminal justice system better than what it is. I will enjoy your questions and go into my plan later.
Thank you, Mr. Moore. Thank you, Judge White. We're going to delve right into the questions here. The first question, according to Court Watch Nola, bail often remains the same or is raised once a case goes to criminal district court, even if the number of criminal charges someone has had decreased since bail was initially set in magistrate court. This often occurs although no additional facts have changed on the case other than the prosecutor has now announced the case is a felony. Do you think that's right? And should this practice be changed? Mr. Moore, we'll start with you.
I believe that the practice is not right. I believe when a person is actually arrested for a charge, and even if they are indicted or a bill of information is set, bail should be actually set in order to ensure that the person will actually come to court. Also, you do take into consideration the connectivities to the city, or whether or not the dangerousness, but you should actually look at all of those issues before setting the bond. And at this point, once the bond comes to the section of court, it's my belief that you should actually review that, especially if many of the charges have already been dropped. The bonds actually should be would drop or reduce or change. A lot of time, I believe we should also look at possibly, instead of having a money bond, in cases, see whether or not a person can actually be released on their own recognizance, depending on what their charges are.
Judge White?
Every case that is allotted to my section, I review the bond. I review the amount of the bond. I actually get a factual basis from the prosecutor, and in the court record, there is a gist. So I look at the gist. If it's a victim crime, in other words, someone has been harmed or they're alleging that they've been harmed, then whatever bond is set, I make sure that there's also a stay away order. I don't increase the bond unless the bond is extremely low, or if someone like the defense lawyer can tell me that their client can make a bond, then I'll always change a bond. If I can give somebody drug treatment, I will order drug treatment and give them even an ROR bond if it's allowed for that statute. And see, many statutes, we cannot give an ROR bond based on what they're charged with. But I think as a judge, I should review every bond because it's a new case to me, and I want to make sure that it's properly set, whether this person is a flight risk, whether they'll show up in court, whether there'll be a danger to the community or danger to others. So all of those are assessed when I set a bond.
Judge White, thank you. Mr. Moore, thank you. The next question: there are no separate booths for defense attorneys to have confidential conversations with their clients in any criminal district courtroom. As a result, often defense attorneys must have extremely important conversations with their client about private court information directly in front of a co-defendant or other individuals who should not be privy to such information. While sometimes judges will allow defense attorneys to use their private chambers, it is where this is allowed. How will you ensure you can have a private booth for attorney-client conversations in your courtroom, or otherwise allow room for these confidential conversations? Judge White, we'll start with you.
Well, first off, I can't allow any defendant that is, what you're talking about is a jail defendant, someone that's not made a bond, because obviously if the person is on bond, then their lawyer and the individual has had the opportunity to speak outside of the court, or they can step outside and speak. So based on the question and the information, it would have to be an inmate client. I cannot allow an inmate client to go into my chambers unless I can send security with them. And we only have 2 security per courtroom, and security is provided by the sheriff. I have to also be careful that the defense lawyers are safely, I have to protect them from their clients sometimes. We definitely have those issues. I actually have 2 small rooms off the courtroom that I have been in for the last several years, and lawyers can go to that area to speak with their clients. Many times, depending on the information that they need to discuss with their client, it requires them seeing their client in jail maybe before they come to court. And if I can, I'll reset a case so that they can talk to their clients. Like, in other words, having another day so that they could go to jail to see their client. Or I'll have the inmate left in court so that the lawyer can speak with their client privately when we're all not in court.
Mr. Moore, how would you facilitate something that would allow for those private conversations to be had in the court any differently than Judge White?
Well, one of the issues is how the court system or the court is actually set up. So it is actually a tight situation. The only way that could be done, and that can't be done on day one, is we have to figure out a way where we can actually have something set up where there is a place by which the attorney and the defendant can actually go and meet together. Because we are dealing with privacy issues, you can't you can't let them go into the judge's chambers. And also because of generally the number of people that are in court, and when I'm talking about defendants that are in jail, it actually makes it very difficult to have private conversation. But one of the issues that you can is if there was a room that was set where the attorney and the client can actually go in and meet and discuss. You also have a situation where it has been done where if it's a situation where you can't actually leave or reset for that day, or you want to deal with the issue on that day, and a lot of times your client do want to do that, you end up asking the court by which they can wait until many of the defendants that are in jail are moved, where you can have an area where you can speak with your client without having people overhearing, or have people who are in the gallery move to another portion. So that's very difficult. A lot of that is dealing with how the court system, the court is actually set, the actual physical room. So those are the ways that I would do it. But the main thing I would try to do is find a way where we can actually set up a room where the client and the attorney can go and discuss any information.
Thank you to both of you. The next question. A recent study by the National Registry of Exoneration concluded that concealing exculpatory evidence is the most common type of prosecutorial misconduct, and prosecutorial misconduct contributed to 78% of wrongful and false convictions in New Orleans. This is an alarming rate of misconduct. In fact, prosecutorial misconduct in Orleans exonerations occurs at least 233 times the national rate. That's 233% the national rate. What are you going to do to ensure that prosecutors are not suppressing favorable evidence in the cases pending in your courtroom? Judge White, we'll start with you for this question.
Oh, thank you. I love this question. As a private lawyer in private practice, I successfully obtained the reversal of many convictions based on prosecutors withholding Brady material. I took my first case because I said, oh, prosecutors wouldn't do that. I had been a prosecutor, and really what I learned later was that as prosecutors, we were not properly trained as to what exculpatory and Brady material is. In my court, I have taken several prosecutors to task to turn evidence over, and I have questioned them on the record with specific questions and had each of the members of the prosecution team answer those questions. Have you reviewed this record? Have you read all of the initial police reports, the supplemental police reports? Have you discussed with your investigator and the New Orleans police or any investigating a law enforcement agency information in this case to be sure that everything has been turned over? I think becoming a judge, this was one of the most important things that I had to handle, and I have handled it. The district attorney through Leon Canizaro's office still has some issues with understanding what should be turned over. I'm hoping that our next prosecutor, district attorney, will have an open file discovery so that these things, that these records and all of the files are turned over to the defense lawyers. If that occurs, then it's up to the defense lawyer to read it. And I'm hoping we'll have open file discovery. That will cut down on quite a bit. I actually had several of those exonerations, and I know what it's like, and it should never happen. And I think a judge should be a stopgate to make sure that everybody is communicating, discovery is being turned over, that the lawyers are taking a look at it, and I'm talking about also the defense lawyers. So this is a really big issue with me.
Thank you, Judge White. Mr. Moore, what are you going to do to ensure that prosecutors are not suppressing favorable evidence in the cases pending in your courtroom if you're elected?
If elected, number one, I will actually make sure that everything is turned over. We need a detailed list of information that is being turned over by the state to the defense. That's the first thing that you look. I think open file discovery is great, but the problem we still have, if we have prosecutors that decide that they are going to hide even the open file discovery. So the issue that we have is, I believe that attorneys, especially prosecutors, need to be put on notice that they will possibly seek disbarment or other disciplinary action by the Bar Association, because what they're doing is illegal. You said, and they need to know that. Now, the other things is correct that defense attorneys must go through and look at all of the discovery. But as a defense attorney, I've found, and going through the discovery, is that a lot of times the state actually hides it and particularly when I was a public defender, that you end up having a hound by happenstance. They actually make a mistake and turn over information that they claimed that they originally had given up, which they have not. And then you use that. So you have to put the honest, and I will state that with the 4 individuals that are running for DA, I'm hoping that they actually will implement this and state that there will be a grave consequence for individuals standing in the place of the state and hiding and doing criminal activities by hiding Brady material or any material.
Thank you, Mr. Moore. This sort of dovetails to the previous question here. In a series of Brady cases from the U.S. Supreme Court, U.S. versus Agers, Kiles versus Whitley, the court recognized that the significance of a piece of evidence and whether it is favorable to the defense can seldom be predicted accurately until the entire record is complete. Therefore, the court opined that a prudent prosecutor will resolve doubtful questions in favor of disclosure. How will you make sure that the prosecutor follows the law and always chooses disclosure over suppression of evidence in the cases pending in your courtroom? Mr. Moore, we'll begin with you.
Well, going back into the thing, as far as even the open file discovery, all of the discovery that they turn over, they must list everything that they have. When they actually, if it's open file discovery, supposedly they have everything and they'll actually turn it over. One of the issues you could say, well, if you actually have an open file discovery, that means that I will allow the defense to actually go over to the DA's office and look at the entire file, case file. And looking at all the case file, that actually will allow them to see everything that the state will have. I understand that the state probably would object to that, saying that some of the information is not Brady, but an open file discovery, if you turn over everything and let the chips fall as they may, I believe that's the best way to actually bring full sunlight into the situation, which allows the defense attorney to go through and look at everything. And plus, the state will actually have to list everything that they actually have as pieces of evidence in the case. That's one thing that I would recommend and actually enforce in my courtroom.
Thank you, Mr. Moore. Judge White, what are you going to do to ensure that prosecutors are not suppressing favorable evidence in the cases pending in your court?
The first time that I caught a prosecutor not turn something over when we were in the middle of trial, I then refused to allow them to use either a witness or the evidence, because that is what you can do. I filed a complaint against prosecutors that withheld Brady material. That's the one way to stop it. And the very first case ever accepted by the attorney disciplinary against a prosecutor was a complaint that I filed against a prosecutor. I also sued the district attorney back when I was a private lawyer for withholding Brady material. If judges will prevent them from introducing either evidence around it or bring it to light to the jury and then file complaints against the prosecutor, that's how you stop them. If they also will do a list of what they've turned over, and the list would say like supplemental report, 12 pages, and the date and the author. If they would put those things in a written document in the record and give it to the defense lawyer in a manila envelope, I would like for them to also give a set of all the discovery to go into the record and to stay under seal until the case goes on appeal, to make sure that everything is being turned over.
Thank you, Judge White. Next question. Pretrial incarcerated individuals are treated as though they have already been convicted of a crime in many of the courtrooms in the criminal district court, even though they are innocent until proven guilty. How will you ensure that your courtroom procedures and your protocols acknowledge and give true meaning to the law that an accused is innocent until proven guilty, and that an accused will be treated with dignity? What are your concrete plans? Judge White, we'll start with you.
You know, this is an interesting question, because having been on the bench for the last 13 years, when I first took the bench, it was lock everybody up and throw away the key. Now everybody's interested in a progressive agenda and let's not lock everyone up. I started a reentry program so that people could get rehabilitation for those that had to go to prison. So when we have individuals that are charged with a crime If it's a crime that's not a violent offense and can have an ROR bond, then I think that's terrific. I'm not interested in making bondsmen millionaires, but I'm also interested in having the community safe and having witnesses to be safe. And that's the issue. I want to assure the safety of the community, and I want to assure that that defendant is going to return to court. Treating them with dignity is what occurs in my courtroom with everyone. I think that we can reduce bonds and allow for a lot of accountability for an individual to return to court. But I don't think everyone can have a free bond or an ROR bond and us expect them to return. Some people have a history, which we are able to get this information from our pretrial services department to show, have they failed to appear in the past? Have they had multiple crimes? Have they been in multiple states with different crimes? Do they have a mental health issue? Can I get them mental health treatment to ensure that they're well and that they will come back to court? So these are the things that we do. But one additional thing, with a change in the guard at the district attorney's office, I think things will be better for the judges at criminal court, because there were multiple times that this past district attorney would submit public comments when a bond was not set to his liking. If it was too low or if something occurred while someone was out on a bond, guess who they're going to go after? The judge that set the bond. So every night that a judge goes to sleep, we worry about whether someone we've let out on a low bond is going to commit some terrible crime, and then the judge is blamed for it. So it's a two-edged sword. So while we're protecting the community, we have to show dignity to the defendants, but we have to ensure that they're going to return and that no one's going to be hurt.
The delicate balancing act, for sure. Mr. Moore, what is your reply? How would you ensure that the accused is treated with dignity and that, under the premise of the question, that they are innocent until proven guilty? What are your concrete?
I believe one of the things that we have to look at, and in many cases, a lot of people that are incarcerated and stand in jail until their trial, a lot of those are nonviolent crimes. So one of the issues that you need to do, again, is look at the bail. If it's a bail situation where they can be ROR, you actually will look at that. You also put in other measurement just in case, where if it's a situation that a person may have somewhat of a sketchy history, but not a situation where the person will not come back. You may have to look at the situation of trying to find a way where we use other ways. And one of this is possibly having some kind of anchor monitoring system. I know we've actually used that before, and I'm not saying use the one where the people have to pay. It may be a situation we have to go out and find a way where we can actually put people on monitoring system by which they can actually go home and go and work and the like. Also, we need to, and I know we have pretrial services, we need to look and see what issues that may cause a person may not to come back, such as if they have alcoholism and the like. But the main issue is how the person, if they are in jail, is how they are treated, not only by the court, but also by the people who are actually representing in the court, i.e. the sheriff deputies and the like. You have to treat people with dignity. Don't talk to them as if they're less than human beings and go forward. So that's another thing that needs to be handled. And telling back to the original, a lot of it we need more space, i.e. able for attorneys to talk to their clients instead of seeming as if they own a chain gang. And that's what a lot of people feel like when they're actually sitting in court. And I would actually do that to try to prevent that and try to make the situation better.
Thank you, Mr. Moore. This might be in the similar vein here, this next question. We know that the way that the New Orleans' criminal courts fund themselves is a problem. The criminal legal system in New Orleans has historically depended on bail and conviction fees to fund itself. The Federal Appeals Court has found this funding system to be unconstitutional, twice in fact. Moreover, the burden of paying those fees has disproportionately fallen on Black families in New Orleans, and on Black women in particular, whose loved ones are overrepresented in the system. Would you support repealing those bail and conviction fees in New Orleans? What are your views on how the criminal legal system should be funded? Mr. Moore, we'll start with you.
Dealing with the funding, I believe the funding actually need to be dealing with the state and the city and the state and trying to find a new funding mechanism to actually deal with the criminal justice system in Orleans Parish. And the other part you said, I want to make sure I answered it correct. You said repealing, what portion was that? Because I didn't hear the whole thing.
Would you support repealing those bail and conviction fees in New Orleans?
I would.
Judge White?
You know, as an elected judge, I can provide testimony at the legislature about what it means, but asking for a repeal is not something that a judge under their ethical guidelines could do. I could provide information and explain that we are being sued because, let's face it, it's the legislature's fault that we are having to assess fines, that we are assessing court costs. We have to, those court costs are broken down for the public defender's office, Crime Stoppers, the city, the sheriff, the district attorney, the court. All of those parties get something out of court costs. So while we were the test case in Louisiana and the one that was taken up, I agree that we can't have a system that is supported on the backs of the poor people that use the system. But we also have to find, the state has to find the money to support the criminal justice system, or we're not going to have the ability to give lawful sentences. I sentenced someone to jail and didn't order a fine of $1,000, which was mandatory. Guess what? The higher court sent it back to me and said the sentence was illegal because I didn't assess a $1,000 fine. So which is it? I got to follow the law. I don't want to do it when it's ridiculous and they can't afford to do it. But when the law tells me to do it, I'm a judge that follows the law because that's what we have to do. But I also go to the legislature to explain. So we're really in a predicament right now where the legislature says one thing with the statutes that we're following, but the federal courts are telling us we should do something different. So we're at a really, we're at the edge of big changes because I think we're going to be without money. The public defender's office is going to be without money because we are not assessing fines, fees, court costs. So what's going to happen in the next year or 2 years when we all run out of money and I don't have staff or we don't have the lights on at the courthouse? Who's going to pay it then? So everybody has to think about that. Somebody's got to pay for the system to keep the lights on.
If you'd allow me to follow up to both of you, then if fees are not the mechanism to fund the system, if you were to advise the state legislature and the legislators on those committees, what would be the funding mechanisms? What options do we have to fund the system?
Oh, I'm sorry. My turn?
We'll start with Mr. Moore, and then we'll come back to you, Ms.
Sorry.
Well, it's several ways that I believe that we can go into the legislature. We have a lot of, I usually say we pay for what we want and we beg for what we need. And that's what the state of Louisiana has been doing all this time. We actually have a lot of funding that are coming in, and as a judge, just opining and saying, well, where can this money come from? Sometimes you can actually look at different sales tax, and I'm not a tax attorney and all that, but there are other mechanisms where we can actually look to raise money. If it's a situation for something that we want in the state, we always come up with the money. So we actually have to have the individuals that are our state legislatures and even the governor to actually sit down and say, okay, this is a problem. We need to pay for what we need. And the criminal justice system is a need, not a want. And whatever they do as far as looking for the money, that I believe they need to go and look at it. As I say, I'm not a tax attorney or a tax person to know where all the different funds were coming from, but the legislature have to go and do their job and actually fund this system.
It sounds like there might be a tax on the books there then. Judge White, if you were to advise the state legislature and the legislators on any committee that would oversee the possibility of funding the system, the criminal justice system? How would you advise them? What are options?
They have to find it. That's the legislature's problem. They fund a criminal justice system, and the largest portion of their budget is to keep people in prison. The Governor John Bel Edwards appointed me to the Justice Reinvestment Committee. I was a voting member. That is a perfect example on how we made legislative changes, and the money that was saved was then reinvested for use in other areas. I received a $600,000 grant from the Department of Corrections through the Justice Reinvestment funding because the money wasn't being spent on incarceration. So if we can do it, and this governor set up an entire new system of moving money around by changing different laws, then they can find the money to fund the system, cut back on time that people are spending in jail. We're still the highest incarceration rate in the world. And so life sentences in most states do not mean life. In Louisiana, it means life without benefit of parole, probation, or suspension of sentence. They could save a whole lot of money if some of those life sentences were not actually a life, that they were given good time, or that pardons were more prevalent. Things like that would be a huge cost savings, and it would be an opportunity to reinvest the funds being used for that for areas like rehabilitation, drug treatment, like I'm handling the heroin addicted people. We could get treatment and rehabilitation to people sooner before they are ultimately sentenced to these life sentences.
Thank you, Judge White. Next question. The Louisiana Code of Criminal Procedure allows a district attorney to dismiss a case and immediately reinstitute the charges despite the filing of a speedy trial motion. This effectively nullifies an accused person's right to a speedy trial. What, if anything, will you do to protect that right and disincentivize this practice that effectively allows the district attorney to evade the bounds of timely prosecution? Judge White, we'll start with you.
Thank goodness this district attorney is on his way out and almost gone. He had actually stopped this practice at some level, but it used to be used quite a bit. There's not a lot that a judge can do, but we sure can be angry. And I can sure let people know what I feel about it on the record in court. I can also, when they dismiss a charge and reinstate 5 minutes later, I can also give them an ROR bond. If it's a murder case, which is usually the type of case that they will reinstitute or reinstate the charges, I can give them a very low bond. And that's what they're trying to do, is to keep people in jail until they're ready to get the case at a trial posture. Either a witness is missing, or their evidence hasn't arrived, or they don't plan on ever going to trial and they think that this is a bad case. So they do it for inmates to be doing DA time. And when you are on top of your work, as I am in court, the prosecutors know that they can't do that type of thing. And I don't think any new district attorney will be doing that. I'm looking forward to a whole new route, whole new way of doing things.
Thank you, Judge White. Mr. Moore, what, if anything, will you do to protect the right of the accused and disincentivize this practice that effectively allows the district attorney to evade the bounds of timely prosecution?
Of course, the problem that we have is that judges can't actually speak out on cases in the public, but the main thing that you can do, you can actually scream your voices from the stand and go from there. One other thing that I believe needs to be done, and a lot of this is dealing with defense attorneys also, they need to be apprised or counting on the time or the timeliness of cases. I've actually seen, as a defense attorney, where there have been some of my colleagues that never actually went through and did the counting to find out whether or not the individual actually has the speedy trial motion actually has passed. So that's one thing, but also, as stated, if it is reinstituted, still looking at everything that you need to make sure that the type of crime it is, the dangerousness, but find a way that that individual actually will have a bond so they can actually go home, and then let the DA who's getting ready to retire, so hopefully we don't have to worry about that, just to explain why the person was released or had a low bond, because that the DA didn't do their job in being prepared for a trial. So it would be my hope and desire with the new DAs that we wouldn't have to deal with that situation.
Thank you, Mr. Moore. Next question. Some judges at Tulane and Broad impose a trial tax, which effectively adds years upon a person's sentence because they exercise their right to go to trial. This has looked like a judge telling an accused person, quote, if you plead guilty today, I'll give you the minimum 7 years. If you go to trial and are convicted, the sentence won't be below 10 years. Will you impose a trial tax? If so, why? If not, why? Mr. Moore, we'll start with you.
No, I would not. A person is innocent until proven guilty. And just because the DA would say, well, we'll allow you to plead to the minimum, the person still have a right to go to trial. And whether he's, if he's convicted at trial, you should not use the fact that he went to trial to say, I'm going to tax you. The public, the people of the state of Louisiana and the city of New Orleans actually hires me to be the judge, to be there and deal with the trial, whether it's a trial, whether it's a situation where they work it out through having a plea agreement or not. I am the employee of the state, of the city of New Orleans. It's my job to go to trial. How dare I or anybody else say, because you won't plead, I'm going to double your sentence? You need to have a pre-sentencing investigation if the person either pleads to a trial or a charge or is found guilty. I believe you should actually have that so you can actually make the appropriate sentence. So I think that is totally off base and really, if you ask me, should be unconstitutional or illegal for a judge to use his or her status of being a judge to say, if you do something that is your constitutional right to go to trial, I'm actually going to hold that against you if you lose. And it won't happen in my court.
Thank you, Mr. Moore. Judge White, will you impose a trial tax? If so, why? And if not, why?
I love the way you're calling it a trial tax, but let's talk about that a minute. First of all, the reality of this is that not every case can be tried because the system would break down. The district attorney's office offers plea bargains in the majority of cases. They're the ones that provide the trial tax. This district attorney says, if you go to trial, we will then multiple bill you. And then the judge will not have an opportunity to go to anything but the mandatory minimum or the maximum on a multiple bill. So the majority of the time, it's the district attorney that is controlling the sentence. Since I've been on the bench since 2008, I've tried over 175 jury trials. In 1 year, I tried 53. Obviously, I don't provide a quote tax if someone goes to trial, but I'm very open and clear in court that if I hear facts during a trial that make me think this is a more serious crime, that the sentence may be longer than I'm offering initially. That is not a trial tax. I love to try cases. I love to try cases as a lawyer, and I love to try them as a judge. But when I hear facts, because when you're talking about a plea, sometimes I haven't even heard motions in a case because it might have been an indictment. So I've not heard a preliminary examination, so I don't know about the specifics. And other times it may be a scenario in which I've not heard from a victim. But once I hear from a victim at trial and I realize the effect that this crime has had on a victim, then the sentence may be longer than if he had have taken, or she had have taken a guilty plea initially and before the court knew all the details. But it's not anything I would ever threaten a defendant with more time if they went to trial. It's usually that the district attorney's office is offering a smaller number, and this is the number. They're more involved in sentencing than the judges are.
And clearly you would not label it a trial tax. Thank you, Judge White. Next question. Court Watch Nola revealed in 2019 that the proper scientific testing was not being used by the criminal district and magistrate court drug testing lab. This lab tests the drug test samples defendants are required to take in magistrate and criminal district courts. Criminal district and magistrate court judges have continued to sanction defendants without proper testing, often sentencing defendants to jail when they supposedly fail presumptively positive drug tests. What would you do to remedy this problem and ensure that drug tests that are supposedly positive are in fact positive? Judge White, we'll start with you.
We allow them to go to another location to take a drug screen. If they wish to go to another location for drug testing, then they can do that. I will offer them weekly drug screens to see what those weekly drug screens show, and that they can also go to another location for drug screens. Many times it's people that are having a drug problem, and I'm not interested in the sanction, I'm interested in the drug treatment. If an individual is coming up positive, I'm not going to put somebody in jail. I'm going to ask them if they want help. I'm going to ask them if they are having a constant problem. Is it a regular problem? Is it something you think you can stop? And then I try to see that I can get negative test results at the courthouse, or I send them to get psychological counseling as well as drug treatment. And some of them will then say, you know what, I really am having a problem. So I don't try to sanction anyone by putting them in jail or fining them. I try to give them opportunities to take additional tests, come back, and usually once an individual knows that I'm interested in their well-being and trying to get them some help for a drug problem or a depression problem or life circumstance issue, then they're more honest and suddenly say, I really do need some help. Can you help me?
Thank you, Judge White. Mr. Moore, what would you do to remedy this problem and ensure that drug tests that are supposedly positive are in fact positive?
And I'm taking the assumption you're saying that based on Court Watch actually investigation, they find that the tests are being actually administered wrong or actually being read wrong. Is that my assumption of what your question is? Okay. And having said that, is we need to find out why the reason, what's the problem with the drug testing area, and we need to actually deal with that as the number one thing. The second thing, I agree that we should actually go through, or I would actually allow them to go out and get a second test to actually go and verify the other. Drug testing should not be set as a matter of trying to put people in jail or get money from them for doing that. I agree that if there is some type of drug problem, we need, with the individual that is coming to court, we need to deal with that. If that means having them to go and talk to a counselor or someone in that area to try to deal with that issue, that's what we would need to do. But the main issue, and I think the crux of your question was, if we have a problem with the testing facility in-house, do we actually then have people who actually take the test and it presumably said that they're guilty of having drugs, then they're fined. They should never be fined for that. But we need to get the drug testing facility up to snuff and make sure that those tests that are being held there are accurate, so we can actually deal with the actual issue of how to deal with people who have substance abuse problems.
Thank you, Mr. Moore. Court Watch Nola again has consistently found that judges will engage in off-the-record conversations, otherwise known as sidebars, pertaining to a criminal case. Sometimes important privileged information is placed on a sidebar, but often important information that would affect the case is also discussed on sidebar and never allowed to be part of the record. Refusing to place important information on the record affects the defendant's ability to appeal his case, since the information placed on sidebar will not be part of the appeal record. What are your opinions on sidebars, and how do you propose to use or not use them if elected? Mr. Moore, we'll start with you for this question.
I believe sidebars, generally when you have sidebars, those sidebars are dealing with information that actually should not come into the public, especially if you're dealing with a trial. You have information that should not come in, and the parties go up to the bench and actually discuss that. I believe those should be held silent, where the general public would not hear that information. Now, if it's a situation that it has a hot sidebar and you have issues that you need to discuss, generally you can have your court reporter to come through there and dictate what actually is being said at sidebar. But we're looking at a case that in many issues, sidebars are not used to, in my opinion, to joke between the judges and the actual attorneys. It's trying to make sure that we have a clean record as the cases go through, and if a person is found guilty, that that information will be stored by which the higher courts can actually review it. But if information that is out there and then you let it out and have a jury to hear it, you actually taint the jury and possibly have a mistrial in that situation. So I believe sidebars, in the context of what I'm saying, are needed and must be had, but we put in the different protections to make sure that the record is protected when a case actually, if it goes on appeal.
Thank you, Mr. Moore. Judge White, what are your thoughts on the role of sidebars and whether they should be part of the appeal record?
You know, I really disagreed with Court Watch on this and was very vocal and talked to them about this initially. But I have also watched my actions and sidebars in any trial or any case and reduced them quite a bit. I think all sidebars that deal with the case should be on the record, or I will go into chambers so that the jury does not hear what we're saying at sidebar if it's information that the jury does not need to hear, but I'll bring the court reporter in to transcribe what we're saying. Sometimes a sidebar is strictly, I'm starving and how long will you be with this next witness? Or I'm prone to migraines. I've had to tell lawyers I'm having a migraine, we're gonna have to take a break. And that's not something I wanna put on the record or let everybody know about because I'm gonna try to push through it. So I'm much more conscious of what goes on during a sidebar conference. And if, for example, many times at a sidebar, you may want to tell a lawyer, you know, don't do that again, or why are you, you know, it's questioning them, or you want to basically tell them, I've told you once, don't do that again. You know, if it's something like that, I never want to do that in front of the jury. So that sidebar is private and it's in chambers with the court reporter. And so those are things that, based on Court Watch and what they've said about it, and they feel like they're, they just think it has a bad look that we're talking privately up front. I limit my sidebars quite a bit.
Thank you, Judge White. So we are going to shift a little bit here, and given the time, this might be the last question, and it might give a little more opportunity to get to know both of you here. This is a question from Facebook. If the voters were going to remember one thing about you before going into the voting booth, what would it be? Mr. Moore, we'll start with you. If the voters were going to remember one thing about you before going to the voting booth, what would it be?
The thing is that I want to streamline the system of criminal justice. I want to make sure that our criminal courts is not a railroad or a high-speed rail for people just going to jail. It's my desire and passion to actually change the system where, while we actually streamline it and actually modernize it, we also make sure that we keep fairness and know that the person that comes in there is not, although they've been charged, that they're not guilty. Give them the respect. Let them go through the process and to fight their innocence. And also in dealing with that, and know that we're not there to actually try to incarcerate ourselves out of the situation that we have in this city. I'm going to be a fair judge. I'm going to be an impartial judge, but I'm also going to be hard on all parties to make sure that we streamline this system and make it a justice system, but instead of what I would call a just us system, meaning that we are actually use our underprivileged and poverty people to push them in jail and use them to pay for this system. That's the things that I would want them to know about me.
Judge White?
I think you said one thing, right?
One thing.
I'm sorry.
that I am a great judge and I need to be continued in the job.
That is one thing. You hit the mark on that. So with that,
Judges have to listen.
So with that, we're going to shift to closing statements here. Since we began with Judge White, we'll start with Mr. Moore.
My name is Dennis Moore, and I'm asking for your vote. I'm asking for your prayers. I believe that this position at this time, I am uniquely qualified and the best qualified to be judge of Criminal District Court, Section 8. My background as a criminal defense attorney for over 23 years, and also combined with my previous career as a software engineer, will give me the opportunity to meld the system and actually bring our system out of the 20th century, and I used to say the 19th century, into the 21st century, to make sure that it's a justice system. I ask for your support, I ask for your prayers, and I ask for your vote. The thing that I do say, that I believe I am the best attorney, lawyer, judge for Section 8. Thank you.
Thank you, Dennis Moore. Judge White, 1 minute for your closing statements.
I haven't heard my opponent say what he's done better than me, whether he's had trials, whether he's done appeals. I haven't heard him say anything about what I've done to be wrong. I don't understand why I have an opponent that thinks he's better than me when I have been lead trial counsel over 100 jury trials. I've been on both sides of the death penalty. I've gotten people out of prison. I've started a program that's now all over the entire state of Louisiana, and I was recognized with Judge Hunter by the American Bar Association as a legal rebel on our novel approach of reentry court. We have received $1,700,000 to continue and to do new ways of medically assisted treatment for our local citizens. I am efficient. I've reduced a huge caseload. I've been independent. I stood up to Leon Canizero. I started the first case management system at Criminal District Court. So what else is it that I can do except continue the good work? And history shows that I've done it. I've been a good judge. I've done what needs to be done. I'm an expert at criminal law. I have the courage, the integrity, the efficiency, the knowledge, and the strength to keep going on and listen to what we listen to every day at criminal court. I would ask that they allow me to continue. I am a fair judge, I'm a compassionate judge, and I enjoy a reputation of being hard on the lawyers and polite to the defendants to help people. Help me continue what I've been doing. I'm number 86, Judge Laurie White, Section A, Criminal Court. Thanks.
Laurie White, Dennis Moore, thank you very much for being part of the forum, and good luck on Election Day.
Thank you so much.
Thank you so much. Good night.
I want to say thank you to both our candidates and to our moderator, Thanh Truong, and all of our co-host organizations who helped put on this forum. This is just the first night. We've got several more coming up. The next one is on Thursday, the 24th. We're here, the candidate from Section E of Criminal District Court, and also, yeah, just Section E actually on Thursday. Thanks again to everyone, and have a great night.
Thank you all for doing this. We appreciate
Thank you.
it.